Court rise.
Yes,
May it please you, my lord. Before the short adjournment, I was going to ask my lordships to look at the learned judge's notes of the evidence. Before we do that, though, may I invite my lords to consider the recent decision of the House of Lords in Cobb and Yeoman's Row?
yes, but by all means, just before we go, though, and to make sure, again, I'm understanding your submission correctly, we're proceeding on the assumption that you haven't made out a concluded agreement.
Yes.
Therefore, you move back to say, well, there was some form of estoppel.
Yes.
And as I understand your argument, that estoppel arose on the receipt of the letter of the 21st of January.
Yes.
2003.
Yes.
That would mean, if you're right on estoppel, the government is bound earlier, much earlier, than it would be on your contract point.
Yes. It arises in this way. I understand, my lord, that would be slightly surprising. But it does arise in this way because on the evidence, the parties both believed they were bound when that letter, the offer letter, was published by the Executive Council.
Yes. That means, in turn, does this estoppel work both ways, so that Mr. Simons is bound at that moment?
It would have to, in all logic, my lord. One couldn't have it both ways.
Yeah.
But they were under a mistaken belief that they were bound, but that is what they considered. They considered themselves to be bound by the offer letter.
So does that mean any contract which fails because it's an agreement to agree will give rise to, in effect, will be binding because of an estoppel?
No, there has to be detriment. The party seeking the assistance of equity through a proprietary estoppel would have to establish it on the faith of the promise, which he incorrectly believed was binding.
But perhaps in 9 cases out of 10, one of the parties will incur expenses in contemplation of finalisation of the agreement. And here there was no detriment as at the time of the receipt of the letter.
No, the detriment followed.
So it couldn't have given rise to an estoppel on receipt.
No, it was when on the faith of that letter and under the mistaken impression that that letter contractually bound the parties that the developers expended money, time and effort on the development, believing wrongly that they were contractually entitled to the development agreement and the conditional purchase lease that it supplied.
No doubt my fault, but the estoppel then doesn't arise on receipt of the letter of the 22nd of January, because at that stage there's no detriment.
No detrimental reliance.
So when does it arise?
It arises at the time when the government seek to resile from the promise, because by that time the detrimental reliance has occurred.
But it must pre-exist that moment, mustn't it? I mean, it's not created, is it, by the resiling by the government?
Well, it's only upon the government purporting to resile.
Well, the problem arises, I agree, but before that, there has got to be a representation that is relied upon.
Yes.
As a matter of logic.
Yes.
Because unless there is, there's nothing for the government to resile from.
Yes. And the promise is that contained in the offer letter.
Well, then that comes back to the question I asked, is when do you say this estoppel arose? On receipt of the letter of the 23rd of January, 22nd of January, or at some other, and if so,
Well,
what stage?
my lord, it's, as I apprehend it, it's only when the promissor seeks to resile from his promise that any question of estoppel can arise.
Well, this is where I'm not following. I follow you in one sense, because you needn't bother about estoppel if the party in question doesn't resile from whatever it is, but there must be something pre-existing which prevents the party from, prevents as a matter of law the party from resiling. And what I'm trying to seek from you is what is that, and when did it come into existence? From what moment could the government not resile?
It's the detrimental reliance on the part of the promisee that gives rise to the entitlement to claim an estoppel. Now, the detrimental reliance.
Yeah, well, that must follow receipt of the letter of the 22nd of January.
Yes. But the reliance, just without doing anything more, wouldn't be sufficient unless the authorities indicate that detriment is a key component. And the detriment pleaded here is the expenditure on the survey, the expenditure on the detailed project proposal, and the time and effort put in by the partners to the project, and not pursuing other development opportunities in the meantime.
So the government could have withdrawn at some stage before that expenditure and not give rise to any estoppel.
Yes, my lord.
Yes. Which means in turn that the estoppel didn't arise on the receipt of the letter of the 22nd of January.
No, that's absolutely
But at some
right.
later stage.
Yeah, that is right. The offer letter is the promise that was relied on, and on the faith of which detriment was subsequently suffered by the promisees.
Yes, you were going to ask us to look at some of the evidence, I think.
Yes. Can I just, though, very, very briefly go to Cobb and Yeoman's Row, my lord?
Yes.
Just on this question of what the parties believe. That's it, volume 1 of the authorities, and it's at tab 13. It was this was a private development agreement, my lords. The key to it was a proprietary estoppel was claimed by the developer because the other party to the putative development, the landowner, resiled from her promise to him that she would make land available to him if and when he secured planning permission on that land. The facts appear from the head note. And their lordships held unanimously that there could be no proprietary estoppel in this case. And key to their conclusions in that regard was the finding, and the undisputed finding, that the parties had not believed themselves to be contractually bound at any stage. It was an agreement that was based in honour only.
Where do you get that from?
So, my lord, well, if you go to the speech of Lord Scott on page 1761, at letter F, The agreement in question is what's called throughout the speeches the second agreement. That was the important agreement. The second agreement was contractually an incomplete agreement. The terms that had already been agreed were regarded by the parties as being binding in honour, but it follows that the parties knew they were not legally binding. And later in Lord Scott's speech at page 1768, my lord.
Which paragraph did you just read there?
I was reading from paragraph 15, my lord, the third sentence, just by letter F.
Yeah, I'm sorry.
No, sorry, my lord. And then at page 1768 to paragraph 17, just above letter D. Mr. Cobb did not spend his, Mr. Cobb being the developer, Mr. Cobb did not spend his money and time on the planning applications in the mistaken belief that the agreement was legally enforceable. He spent his money and time well aware that it was not. Mrs. Leal Mannering, the landowner, did not...
I've now lost you. Page
I'm sorry, my lord.
1768.
1768, my lord.
Just above G?
Just above D.
D.
D, my lord.
I do beg your pardon.
Sorry. Mr. Cobb did not...
Yes.
Spend his money well aware that it was not. Mrs. Leal Mannering did not encourage him in the belief that the second agreement was enforceable. She encouraged in him a belief that she would abide by it, although it was not. Mr. Cobb's belief or expectation was always speculative. He knew she was not legally bound. He regarded her as bound in honour, but that is an acknowledgement that she was not legally bound.
They relax.
Yes. He knew that it was entirely, his fate was entirely dependent on her behaving honourably. And to page 1772, my lords, paragraph 37. Perhaps I could invite my lords to read that paragraph.
Well, he uses binding in honour in a rather special sense there, as being an unenforceable promise to perform an unenforceable agreement.
Yes.
So it's an agreement to agree.
Yes. But it's, yes, but it is, the point, my lord, in my submission is that it is neither of the parties at any stage believed that their agreement was one that was legally enforceable. And that, in my submission, is the crucial distinction between the situation that pertained in that case and the one that pertained in this case, because rightly or wrongly, the parties to this agreement believed that they were parties to a legally enforceable agreement. And that is what the approach taken by my Lord Clerk gave rise to reliance that is potentially actionable, because the expenditure of time, effort by the developers was in reliance on what they, and indeed the other party, believed was a legally enforceable agreement.
So when did this is a case in which you're relying upon Bradford Stockers to give you your cause of action, yes?
Yes.
So when did the cause of action accrue?
The cause of action accrue. Well, my Lord Savile, my analysis would have been that the cause of action accrues at the point in time when the promisor purports to resile. Absent that,
So when would that be?
that would be when Michael Missick wrote a letter. Well, there was a meeting in May of 2004 when Michael Missick indicated to Carlos Simons that his group were not going to have the 35 acres. And moreover, that it had been committed to other developers. And that's part of the story that we...
What is the representation?
The representation is that contained in the offer letter that we were looking at this morning. That you will, the government will give you a development agreement and a conditional purchase lease or land freeze, as you choose, in respect of 35 acres of land to the north of Amanyara.
It's a development agreement and lease, really, isn't it?
Yes, it's the lease.
I know the lease in at least one of these drafts is a schedule.
Yes.
These are two legally distinct agreements, aren't they?
Yes.
That in itself is not necessarily fatal to your argument, but it's a representation that this company, and I think for these purposes it probably doesn't matter that it's not formed yet, that this company will be given a development agreement and a lease of the 35 acres.
Yes.
Is that it?
Yes. The way the standard...
That wouldn't be enough by itself, because the development
Can I take...
could mean almost anything.
Can I just take...
So we're back to what the terms of the agreement would be, whether or not the representation was going to be in standard terms or whatever, aren't we? We're back to the same points we were discussing before.
Yes. The way it worked in terms of the standard development agreement is that the developer would sign up to the development agreement, and under the development agreement he had certain obligations. Not surprisingly, perhaps the first of his obligations was to secure planning permission for the proposed development. It's only with the grant of planning permission that he becomes entitled to the benefit of the conditional purchase lease. And the conditional purchase lease then, when the development agreement is executed, the conditional...
I follow all that, but your representation, maybe the government will provide a development agreement.
Yes.
It wouldn't be enough by itself. We'd have to know, for it to be a clear and unequivocal representation, we'd have to know what was meant by development.
Yes.
So we're back to the very same point we were discussing before. Namely, you would say, is this right, a development agreement on standard terms, the usual terms.
Yes.
So you have to spell that, or at least any judge finding the existence of
Yes.
spell a representation in those terms out of the evidence.
Yes. Yes.
Nobody's done that so far.
And lease.
And lease, yeah.
Yes. Well, the evidence is, the evidence that was heard at the trial was that the agreements are in standard form. No, well, true, it is, and we have examples of such documents in the papers. Our case is that there were standard form development agreements and there were standard form conditional purchase leases. And it is, that is what we were promised.
Yes, but the standard form, as you've already accepted, varies from time to time and could well have varied between the time of the dispatch of the letter and the coming into existence of the proprietary estoppel.
My lord, yes.
But as my Lord Clerk has just said, isn't it? Whichever way you put it, it comes down to the same thing. That, or putting it another way, you either have an agreement as to all the terms of the agreement of what is to happen, or you don't. If you don't have any estoppel either, because ex hypothesi, there can't be any clear, unequivocal representation.
Well, my submission is that the representation is that you will have a development agreement and that the common understanding of the parties was that was the standard form of development agreement, extant at the time when granted. I'm sorry to repeat myself, but really, my lord, that was what the developers thought they were being promised. That was what they understood they were being promised, and didn't expect to be in a position to alter the standard form agreement. Didn't think that was a matter that would be an option that would be open to them. And my lord, one must bear in mind in all this that the land in question, because of the belonger involvement in this project, the land was to be granted to them at a very significant discount. So commercially, the disadvantage of being stuck with whatever agreement the government gives you is offset by the fact that the capital value of the land is so significantly reduced. So one can well understand why developers would be prepared to enter into an arrangement on these terms.
You were going to show us some evidence, and I think
Yes.
we've continually interrupted you and stopped you doing
No,
that.
no.
So show us.
Yes, I'm sorry.
I think it was what the evidence you said was before the.
Yes,
the
that's
judge.
my lord. Yes, I took you to Cobb. A, to distinguish it, and B, to explain why in my submission what the parties believed they had achieved was significant.
Yes.
The judge's note of the evidence at trial begins at page 1049 in file 3 of the record. The evidence of Derek Taylor, his record of the evidence
I'm so
of Derek...
sorry, can you give me that page again?
Yes, I am sorry, Mark. It's
bundle 3.
It's bundle 3, beginning at page 1049.
Thank you.
And it's to page 1058 that I would take, my lords, because that's the learned trial judge's record of the evidence of Mr. Taylor, the signatory of the offer letter, the former chief minister. And if one goes to 1061, that's the back end of his cross-examination and some questions that he was asked by the judge. About 6 lines down, he's talking about how the monetary side of these deals was determined. He says, valuer gives market price, and we see that happened in respect of the 35 acres. Government decides amounts. It was government policy. Belongers get 50% discount for commercial, 75% residential. Not communicated separately, it was policy. And then next sentence, next answer but one, policy was understood, it was published. We had a booklet dealing with Crown land. It said belongers get 50% discount for commercial, 75% for residential. At the end of his evidence, when he was asked questions by the learned judge, he said, I regard government as bound when approved by EXCO. Agreement was standard. Attorney General prepared draft. So as far as he was concerned, the government was bound when he sent out the offer letter. Now, the recipient of the offer letter on behalf of the developers, of course, was Mr. Simons. He was the next witness to give evidence.
So that he means on the date, on the 22nd of October? No, sorry.
That's, my lord, that is as I read.
That's not your case.
No, it's not my case. No, that was his belief, though.
So his belief and your case are not quite the same thing. I thought your case depended on his belief.
No, my case with regard to proprietary estoppel, one of the bases of my case on proprietary estoppel is that both government and developers believed that they were contractually bound. Mr. Simons, this is at page 1065, my lords. Line 56. 22nd of January 2003, I received a letter from Chief Minister. And 3 answers further on. Land Valuation Officers, Mr. Hoser. We were happy, and this must be a reference to the offer letter, we were happy although it spoke to 35 acres instead of 57. We engaged architects to prepare details. We had to pay for the survey. And then 2 lines further down, government would get opinion of land valuation officer. That would be the value. The only adjustment would be for belonger discount. So far as I was concerned, there was no need for further approval. Principal terms of our agreement had now crystallised. We had agreement, 35 acres north of Amanyara, to be developed as we had proposed. It's not entirely clear from the evidence of Mr. Simons at what point he came to the conclusion that there was a binding agreement. Suffice to say, he certainly came to that agreement. He came to that conclusion. I apprehend it's that evidence, and there was other similar evidence from other members of the partnership, but it's that which led the learned judge to conclude, as we saw before the short adjournment, at paragraph 41 of his judgment, page 1041. The arrangement was undoubtedly intended to have legal effect. That was the burden of the evidence he heard. It was intended to have legal effect, and the key players believed it had legal effect. So that when they invested time, money, effort on this project and didn't pursue other projects, they were doing so on the faith of the representation contained in the offer letter and in the belief that they were the beneficiaries of a binding legal arrangement. And that is why, when they had suffered detriment in that sense, through the expenditure of time, effort, and not embarked on any other schemes, and the government, after it had changed its political complexion, sought to resile from the agreement, we say behaving unconscionably. It's at that point in time that the developers can be heard to say, no, you are stopped from doing that.
And what's the extent of the equity they're entitled to?
The grant of the development agreement and the conditional purchase lease.
But the Court of Appeal found they'd only spent $11,000, and that...
Yes, that's the evidence of the monies they'd expended. That's right. What the Court of Appeal ignored, although they recorded it in their judgment, but it wasn't just the matter of the money that had been expended, it is the time and the effort that had gone into it, and the fact that other opportunities had not been explored in the meantime, because between the date of the offer letter on the 22nd of January 2004 and Mr. Missick purporting to resile from that on the 20th of May 2004, nearly 18 months had elapsed. And that was a period of 18 months during which this consortium, these project principals, had been investing all their time and effort on this project, which they believed they were entitled to.
Well, the judge didn't rule on this aspect of the case at all.
No,
The Court of Appeal, you say, got the facts wrong. So even if you were right on this part of the case, wouldn't you be asking for the matter to go back for determination of the facts?
yes. Well, in terms there is one of the most troubling aspects of this case, of course, is the inadequacy, the patent inadequacy of the disclosure given by the government. So far as the question of unconscionability is concerned, in the light of the findings of the old report with reference to Mr. Missick, one has every reason to conclude that his motives for seeking to resile from this arrangement with these developers were bad motives, that he was motivated not by any legitimate purpose, but for an illegitimate purpose.
Yes, but if you're right on your representation and detriment in the form in which you put it in your written case, so the representation's clear, it's relied upon to the detriment of your clients, then you've got yourself an estoppel, do you say at that moment? Or you may have, depending whether there was a good, bad or indifferent reason for the government bailing out of it.
The conscionability or otherwise of the promisor when he seeks to resile from the agreement is relevant, my lord. It's best expressed, I apprehend, in the speech of Lord Walker in the Cobb case, where the thrust, my lords are probably aware of the passage I mean, that you, in Lord Walker's opinion, you must, when all the other component parts of a proprietary estoppel appear to be in place, then you stand back and decide whether what happened was conscionable.
Yes.
If it appears unconscionable, then the way is clear to find that an equity's been established. But if what has happened when examined does not strike you in that way, then you might not come to that conclusion.
So this unconscionability question comes in fairly well down the list of issues for determination. It's not relevant to the contractual issue, because that's a question of construction of the contract.
Yes.
It's not relevant to whether there was a clear and unequivocal representation, but it may be relevant after that, or would be relevant after that.
Would be on the authorities, my lord, because, of course, it goes without saying, proprietary estoppel is an equitable remedy, and it's whether in all the circumstances one has a case that would justify invoking the equitable relief. And at the heart of that, the question of conscionability lies, or unconscionability rather. Should I take my lords to the passage in Lord Walker's speech to which I referred?
Well, do. But I understand from what you said to Lord Clark that unless you've got the other elements of an estoppel in place, the conscionability or unconscionability doesn't arise. But by all means, show us the passage you're interested in.
Well, I can do that quite briefly, my lord.
Well, I suppose you'd say if you've got that far, it was obvious, it was on the face of it, it was unconscionable to resile from it, unless it's really over to the other side to say that it wasn't unconscionable.
Yes, yes. What one got, well, I'll take my lords in a moment just to the relevant correspondence, because it bears on the point. But in the it's page 1788, my lord. This is in tab 13 of the first volume of the authorities bundle. I might invite my lords to read paragraph 92. And learned Lord regarded as playing a very important part in the doctrine of equitable estoppel in unifying, confirming, as it were, the other elements.
Yes, I think you put it a slightly different way. As I read this passage from Lord Walker's judgment, it is you look at what Mrs. Lyle Mannering's conduct was. You can categorise it as unattractive, but it wasn't. She hadn't, in fact, expressed herself as being bound other than in honour, so it's unattractive, but it's not unconscionable. So here, if in fact the representation isn't clear and unequivocal, then it may not have been a very honourable thing for the government to do, but it's not unconscionable.
Well, I go back, my lord, to the distinction that I draw between our case and Cobb. The distinction being that in Cobb, both parties throughout knew that Mrs. Leal Mannering was only bound in honour, so that it was, if you will, all that Mr. Cobb did was done speculatively, and he knew that full well from the start. Whereas in our case, both parties believed that they had a binding legal agreement, and everything that the partners did in furtherance of the development project was done on that basis.
Yes, so I follow that. Although you would have to say, since we're proceeding on the assumption that they hadn't got a legally binding agreement, that in your case, both parties mistakenly believed that they had.
Yes, just so, my lord. Just so. But I mean, I think, as my lord observed before the short adjournment, that if there was a legally enforceable agreement, there would be no need for them to fall back on the doctrine of proprietary estoppel, unless it were to find an answer to the memorandum in writing point, which we've not looked at, but. The repudiation of the agreement is put in writing by Mr. Missick on the 20th of May 2004. That's the letter at page 363. Perhaps I should take my lords back a step, though, because the letter of the 11th of May 2004, which is at page 359, was written by Mr. Simons to Mr. Bean at TC Invest after Mr. Simons had attended a meeting with Mr. Missick. And had asked at the meeting about the further draft of the development agreement that was being waited for. And as the letter records, at the meeting the question arose as to whether the Northwest Projects Limited property had to be north of Caicos Resorts Limited. That was a question raised by Mr. Missick. Mr. Simons said he would go away and consider that matter. And by this letter, he was sending to Mr. Bean the letter that he'd received, the offer letter from the Chief Minister, and the record of the survey of the property and the monies that had been paid in survey fees. He said, in the circumstances, I regret that a move to the south of Caicos Resorts Limited cannot be accommodated at this stage. We would prefer to remain where we are. I should be grateful if you would please take this matter up with the Chief Minister and confirm that the development agreement may proceed on the basis of the land currently allocated. That being his understanding that the land was allocated and that there was an agreement in place. And that provoked the response from Mr. Missick 9 days later at page 363. Referring to the meeting regarding your interest in developing a mixed-use project on Crown Land Northwest Point, Provo. As I indicated at the meeting, government would be prepared to allocate to you land to the south of Amman Resort site for your project, as the property which you have expressed an interest in is committed to another developer. I trust the development agreement can now be finalised without further delay and wish this project every success. There was never any evidence produced as to this purported commitment to another developer. Mr. Missick didn't give evidence at the trial. Nobody gave evidence at the trial as to why Mr. Missick had repudiated the agreement in the way that he did at this time. And there was no evidence or disclosure with reference to another developer or a commitment to another developer or anything of that sort.
Did Mr. Simons reply to that letter of the 20th of May?
Yes, he did. He gave a very fulsome reply, my lord. If you oh, well, it's 369. There's a letter at page 369, my lord.
Perhaps you can't have cut him to the quick, since it took him nearly a year to reply to it.
Oh, when you're... Oh, I'm grateful. There's a letter, yes, this is a letter, 456, my lord, I'm grateful.
Yes.
Friend.
It doesn't assert either of the cases you're running today. Either or any of the cases you're running today. But I dare say you can say, well, Mr. Simons no doubt still hoped that the deal would be resurrected, and so he didn't want to put the Chief Minister off too much by anything too assertive.
I apprehend that's right, my lord, and this was actually touched on in evidence at the trial. They were
so all this is a long way down the...
treading carefully, as it were.
Speaking of myself, it appears to me it's very unlikely this appeal is going to turn on this part of the case. I mean, it may be that it will be relevant, I don't know, but...
Well, have we completed your submissions on the preparatory estoppel point?
Yes, unless I can be of any further assistance, my lord, in any aspect.
What, there are a couple of other points.
A couple of other points. There is the point with regard to the costs order that was made at first instance. At first instance, the learned judge made a costs order against the first respondent, ordered them to pay the plaintiff's costs on an indemnity basis.
Yes.
That's
And the Court of Appeal was no order as to costs, is that right?
Yes, that's right. That's right. We've addressed that aspect in the response to the respondent's case, beginning at paragraph 38. Now, the relevant judgment as to costs
What does the expression "the land was mutated" mean?
changed. Mutation is the phrase. So if a plot of land is subdivided, that's referred to as a mutation.
Right, thank you.
I wasn't familiar with the word being used in this context before either.
Yes.
No. Perhaps while on you'll have seen in the appellant's case that the question of costs is addressed at paragraphs 67 to 70 at the end of the case.
Do we have the Turks and Caicos cost rules anywhere?
My lord, they proceeded on the basis of the old White Book, the old rules of the Supreme Court. I do have a copy available. If
There's the new provisions for split orders as to costs.
No.
Rule in Turks and Caicos.
No, CPR hasn't found its way out to the islands yet, my lord.
It was presumed, well, as I recall, there was power under the rules of the Supreme Court to make such orders, wasn't there?
I think that's right, my lord. I think that's right.
I think it's certainly right, because CPR hasn't penetrated as far as Northern Ireland, but orders such as this have been made. Relatively rarely, but nevertheless they have been made. Under the White Book of 1999, I think it is.
Yes.
Yes.
The judgment as to costs, there was a separate judgment handed down by the learned trial judge. We find it in the record file 3 at page 1047. It's the back of his judgment.
Well, that's where I got the mutated from.
And the
Well, is there anything else you wanted to say at this stage?
should I take you, my lord, or perhaps you've been there already, what the Court of Appeal said on costs?
If you could give us the reference at least.
Yes,
that would help.
it's at page 1336. my lord. 1336 in volume 3. In short, my lords, the Court of Appeal ought only to have interfered with the costs order made by the learned trial judge if they were satisfied that he'd erred in principle. The decision of the Court of Appeal was itself in error in coming to such a conclusion, because the learned judges in the Court of Appeal, with respect, took an unduly narrow view of the basis of the trial judge's decision on the point. The trial judge's decision on the point, from the wording of his costs judgment, quite clearly he took an extremely dim view of the conduct of the government, not only in relation to the transaction, if I can put it broadly in that way, but also in relation to their conduct of the litigation and the proceedings that came before him. The failure to give timeous disclosure or complete disclosure, the failure to comply with directions, and came to the conclusion and came to the decision that this was one of those exceptional cases where a claimant, albeit in the event successful, should be ordered to pay the costs of the other party. In our submission, that was a fully reasoned judgment in all the circumstances of the case. And of course, this was a learned judge who had dealt with the interlocutory stages of the litigation as well as the trial itself. And so was quite well aware of what had been going on in terms of the conduct of the parties through the litigation. In those circumstances, the unduly restricted view that the Court of Appeal took of his decision on costs, which is alluded to in paragraph 34 of the Court of Appeal's decision, page 1336, that unduly restricted view rendered it inappropriate for the Court of Appeal to come to the decision it did and to conclude that the learned trial judge had erred in principle. In our submission, the decision he made was well within the ambit of his discretion and ought not to have been upset.
Can I just ask you this? When the judge says at the bottom of page 1047, he refers to an application for a caution being rejected. What application was that?
Prior to the trial, my lord, there was an application by the claimant for a caution on the 35 acres to prevent any disposition of it prior to the trial. The Lands Registry refused to enter a caution at his request on what the judge regarded as a spurious ground that the caution couldn't be entered because it was Crown land. Because the Lands Registry wouldn't enter a caution, the claimant made an application to the trial judge, an interlocutory application for an injunction against the Lands Registry ordering that a caution be put on the land. The trial judge, on considering the application, didn't grant the injunction, but what he did do was to give directions designed to secure a speedy trial of the matter, and he made an order for costs against the government. We find...
So that order still stands?
Yes. That order.
Whatever happens here?
Yes.
But this was not was any of this misconduct in the conduct of the litigation?
Yes. Yes. Well, he refers to it, if one goes to 1048.
Sorry, what's the date of the action, of the writ?
Beginning of file 1, my lord.
June 2007.
Yes, that's what, yes, 15th June 2007 is when the proceedings were commenced.
And the so-called mutation is June a year earlier.
Well, yes, but there was nothing shown at the registry. It was anyone who did a search would have thought there had been no mutation at all. It was only subsequently that oral evidence was given of a mutation. But the application...
The application for the caution then was before these proceedings began, was it?
Yes, it was, my lord.
At any rate, your side won that and have an order of costs in their favour in relation to that.
It's if you go to page 41, my lord, this is the affidavit of the plaintiff.
You didn't win it, but you got an order for an early trial and you got costs.
We got our costs, yes.
But surely the point about costs is that there's nothing to suggest that the plaintiffs would have been deterred if they had discovered that there had been a mutation. Is there?
Well, one simply doesn't know, my lord. One doesn't know.
But there's got to be some sort of nexus between the alleged wrongdoing and the impact on the litigation, does there not?
Yes. The reference at page 1048, my lord, at the end of paragraph 2. The approach taken by the Court of Appeal was that the concerns expressed by the learned trial judge about disclosure and the general failure to produce relevant documentation is solely referable to the question of the mutation. But in our submission, it goes wider than that. It's a comment on the general conduct of the litigation.
Yeah, it's relevant to unconscionability, isn't it?
Yes.
Yeah, the point that you make, your submission, is that, and I think I'm just repeating what you've just said, is that it's not just the fact that the land was mutated, it's the way that the respondents conducted themselves during the trial, which meant that nobody actually knew what was going on until a very late stage indeed. And the judge obviously took an extremely dim view of that. So it's not correct simply to say, well, okay, the respondents were entitled to mutate because there'd been no injunction against them. That's, I think, what you're saying is that's not the point made by the judge.
Just so much. Yes. Just so, he was taking a much broader view of the conduct of the parties, including their conduct in relation to the litigation, and took an exceedingly dim view, and in those circumstances concluded that this was one of those unusual cases where he was driven to make an order for costs that would not be the usual one.
Yes.
Mr. Sanders, in paragraph 3 on page 1048,
Yes.
as part of the judge's reasoning, he says, I'm concerned with the effect on the plaintiff. It was disastrous. It caused him to bring an action relying on false information provided by the land registry. In other words, he brought the action in 2007, not knowing of the mutation in 2006. And the Court of Appeal deals with that at 1336. It is hard to see, however, as the judge appeared to suppose, that had this information been provided at an earlier stage, it would have deterred the appellant from bringing the action in the first instance. And in the previous sentence, had the eventual decision gone against them, they may have been compelled to unscramble the mutation. And the judge used the word unscramble, or to pay damages in lieu of a specific performance were thereby then impossible. So the Court of Appeal took an entirely different approach to the judge in ruling that the judge was simply wrong in saying that this action would never have been brought. Were they not entitled to do so?
They were entitled to say that, my lord, but our submission is what they were not entitled to do was to take the unduly restrictive view that that was the rationale and the only basis for the costs order that the learned judge made. Our submission is that there was more to it than that. There was a lot more to it than that.
But is there any evidence in support of the judge's conclusion that he gives as to what your clients would have done?
No, there's no evidence either way. I apprehend it would be hypothetical anyway.
Right.
But no.
So I think the case against you is that the judge had no business making that finding because there was no evidence to support it.
If his decision on costs...
And that's right, isn't it? There isn't any evidence to support it.
No, there isn't. But he was...
So the judge had no business making it.
Well,
he might have been right to say, as my Lord Savile says, that the defendants behaved in extremely unsatisfactory in a whole series of ways, notably in particular your points about discovery and the like.
Now, it would have been more happily phrased if he'd said that the plaintiffs would have had an opportunity of thinking twice or reconsidering whether they wanted to. And I apprehend that is the position. Had they known that the land was gone, mutated, gone to other parties, it is entirely possible that they may have decided that they were not going to pursue litigation in order to secure
Although
it.
it is fair to say that your side have not actually put any evidence before the court on any of these issues going to that point.
No.
Is that right?
No. And
Though they could have.
Yes. And if it were the case, my lord, but if it were the case that that was the sole basis for the learned trial judge's decision on costs, then my argument would be more difficult. But my submission, as my lords know, is that the basis of his decision was far wider than that. Unless I can be of any further assistance, my lord.
No, thank you very much.
Thank you.
What we'll do, Mr. Myers, is rise for a few minutes to see where we're getting to.
If you please, my lord.